Welcome to Case by Case. This is a podcast brought to you by Callum Chain or Luke Sadkovich. How are you today, Callum?
I'm very good, Luke. How are you doing?
I'm very, very, very good. I'm super excited today because we've got a very special guest on the podcast with us. We've got Mr. James Turner, KC of Quadrant Chambers. Welcome, James.
Good evening, Luke, where you are. It's definitely morning here.
Good evening where I am. I'm actually coming to you from Australia, and Cal and James are on the other side of the world, so to speak.
It's super exciting to have James and particularly to have a KC on the podcast. That's a big step for us.
Sure is. I think our first, right? Is it fair to say?
Yeah, it is. It'll be interesting to see how this goes with someone who actually knows what they're talking about.
You're talking about yourself again, Callum.
If only.
Yeah, exactly. No, and you know what? I won't jump straight into the case, but I think this is a really good case to get a KC on, if I can put it like that, because there's some real knotty legal, procedural, appellant type issues in it, as well as some brass tacks, quantum issues for a sale and purchase dispute in the commodities field. So, yeah, really welcome, James. Thanks for joining us. We appreciate you jumping on. And for many of our listeners, they'll be well aware of who James Turner KC is. His reputation in the field is, absolutely outstanding. And I thought today we might just do a little bit of a longer intro than we usually do, Callum, just to kind of give a bit of background about James and what his practice focuses on and that kind of thing.
Yeah, and I think also we have a lot of listeners who I think are quite early in their careers, or even just pre-starting their careers. And it's we obviously come from the solicitor side of the fence, but it's interesting to talk to someone like you, James, with your background and expertise, and kind of give some insights on the barrister side of the legal career for people who are coming through that way. And I know I've actually blocked Twitter myself, but recently from overuse, but I know that you're quite active, or at least historically when I was on Twitter, you were quite active as well, and kind of a public figure, if you like, in the shipping litigation world. So it's I'd be interested to talk to you a little bit about that too.
Well, yes, like you, I'm afraid I've left Twitter.
Irony.
Not so much for the work reasons that you give, but it had just become quite a depressing place.
Okay.
Since the Musk takeover, so I'm afraid I'm only to be found on LinkedIn now if anyone wants to find me on social media.
I remember it must have been a couple of years ago now, you had a profile on Twitter that was a kind of useful resource, I think, for anyone in the kind of shipping or legal world, with interesting commentary on different cases. And I suspect that probably as some people in the early stages of their career or pre-career, hopefully get some benefit from this podcast. I think people probably got a similar benefit from following your Twitter feed. Well,
that's kind of you. I hope so. It reached its peak around the Priti Patel's pushback policy when, although I don't actually do international human rights law, I found myself being interviewed on a whole variety of media. But I'm very pleased you introduced me as James Turner from Quadrant, because when I appeared on the BBC News that one evening, I was introduced as James Turner KC from One King's Bench Walk, which is not who I am at all. There is another one.
We got the right one.
You did. Well, I hope so.
Well, thankfully, I think we know the difference between those sets of chambers and who we deal regularly with there at Quadrant. So, yeah, look, for those who don't know, James specialises in cross-border commercial disputes with a keen focus in international arbitration, energy, shipbuilding, offshore construction, shipping, banking, and throwing commodities there as well. James has been shortlisted for the Legal 500 Environmental Sustainability section as the Bar Champion of the Year 2024. I thought that was an interesting one. What's that about, James?
It's not even a side hustle. It's a sort of nerd hobby in ship recycling law. I've been on numerous webinars and written a certain amount about it as well. So that was part of it. And also I've got involved in a book on maritime decarbonisation, which came out late last year, and I wrote a couple of sections in a chapter that was corralled by a solicitor at Stevenson Harwood.
Very good. Some of your old colleagues there, Callum.
Exactly. I think I know who you're talking about. They've been quite involved in the Blue Visby project over there.
Exactly.
And we've seen a lot. I mean, it's a very interesting time to be a shipping lawyer with a decarbonisation bent to your practice, because there's just so much going on in that, whether it's EU ETS, CII, EEXI, or Fuel EU, which is the next one. It feels like, we had IMO 2020 and then a brief period of respite, and now it's just every year there's a new piece of legislation with its own difficulties that people have to navigate, all aiming for what I think everybody sensible would say is a good solution of trying to decarbonize maritime trade, but each with their own challenges, and implementation of these multi-jurisdictional international regulations is always tricky, and people will always find issues, and there are issues with a lot of this legislation. So that's been a fascinating part, certainly, of my practice in the last couple of years as well.
I'd like to tap you up for your knowledge on that. I mean, I completely agree with you. And one of the fascinating things is the tussle between the IMO and the US and the EU, both of which have got fed up with the IMO's, as they would see it, foot dragging. And so the IMO is itself having to accelerate. But one can query whether CII and so on are actually the right way of going about it, because simply reducing the carbon footprint of a ship doesn't help very much, because the best way of doing that is to slow the ship down. And then if you've got the same volume of trade to carry, you just need more ships. And exactly, kind of back where you started from. So,
and you also, certainly under CII, you disincentivize any kind of triangulated trade where the vessel is constantly in a laden state, which is actually the most effective way to carry goods worldwide. So you end up with a slightly odd situation where a long ballast leg, effectively doing nothing helpful for international trade, is the best way to reduce your CII. But I say this on the backdrop of, it's obviously well-intentioned, it's well-intended, and the idea is to try and find ways to reduce emissions. It's just we're in that early phase where it's ironing out the issues with the legislation. Is something that I think all industry participants need to have an interest in.
Is it one of the main issues with this kind of tradition, I suppose you'd call it, in just sailing fast and getting to the discharging port and then waiting, and that actually, a system, whether it's technological or, maybe regulatory as well, that keeps vessels moving at their kind of most ecological friendly pace is probably a better approach, rather than this just take off and wait.
I think that's what the whole Blue Visby thing is about. And I think there's definitely a place for that, because the savings they've modelled can be pretty significant, at the order of 15 to 20%. And of course, even if you manage the transition into alternative fuels, and there's quite a lot of skepticism about whether that will be possible, but even if you manage that, those fuels are going to be very expensive to produce. They're going to be relatively scarce, because shipping is going to be competing with other industries for access to those fuels. A system which then ensures that you don't burn more of them than you have to would be very, very welcome in the future. So it's not just about reducing emissions now, it's about conserving feedstock in the future. But there's no one silver bullet in all of this. And there's a lot of talk about biomethanol and batteries and nuclear even, and ammonia, and each of them has their own problems. Each of them is going to have their own supply constraints. Each of them is going to have a security problem around it. I mean, the idea of dumping a sort of VLCC's worth of ammonia into a sensitive ecological area is just enough to keep one awake at night. Even if it's a non-persistent chemical, it's still going to wipe out quite a lot of marine life. I would have thought that. I'm not a biologist. But so all of these things need to be thought about, and the infrastructure built for them. And what is interesting is to see that there are orders being placed for very large ammonia carriers before the market is there, really, for them to operate. So people are making some long-term plays in the market, which is on one level very good news, but it's going to be fascinating and probably in part painful to see how that develops over the next 2 to 3 years, really. I mean, the time horizons are now getting shorter and shorter.
Yeah, well, look, all fascinating stuff. I'm sure we could do a whole podcast on this topic. For those listening in that may not be as up to speed on the split bar kind of scenario that we've got in England, which is where James primarily practices. By the split bar, what we mean is there are solicitors and barristers, and solicitors effectively are the ones who are client-facing and work up the cases, prepare the cases, and the barristers are the advocates, the oral advocates who go into court or arbitration and argue the cases. They're on their feet and do the arguing. Callum and I are actually solicitor advocates ourselves and have dabbled here and there, have handled a few arbitrations, but James is right at the top of the pile, if I can put it like that, in terms of the hierarchy of advocates, and that's where King's Counsel KC sits. It's from the pool of KCs that ultimately get appointed as judges or sit as deputy judges while still KCs. And James not only is an advocate in court, but also in arbitration. He sits himself as an arbitrator, and I think that experience of having sat as an arbitrator and having been and is an advocate is quite useful for this particular case, because we've got a case that has gone through the arbitration levels. We're talking about a GAFTA arbitration, so it's gone to the appeal board, and then using a quirk of English law that doesn't exist in all jurisdictions, where you can appeal from an arbitration award into the court system on a point of law. That's what's happened here. And then the decision has worked its way up all to the top in the court system. So really useful experience there. James is a preeminent barrister, and I could read out a number of quotes here from Chambers and Legal 500 saying so. But let's get into it. Hey,
I think let's get into the case. It's an interesting one. We're in the Supreme Court today with the case of Sharp Corp Limited and Viterra BV, because Viterra was previously Glencore Agriculture. And this one was handed down on the 8th of May this year. So pretty recent. And for those who like citations, the Supreme Court citation is 2024 UKSC 14. When this was handed down, there was quite a lot of fanfare around mitigation and this kind of enshrining mitigation as a Supreme Court decision. I'll be interested in your take on that, James and Luke, as to whether it really changes anything about mitigation or just kind of restates the principles as they already were. It comes out of a dispute relating to two sale contracts for peas and lentils. I don't know, Luke, if you want to talk through the background to it before we get into the legal stuff.
What's fascinating about this case is that actually most of the Supreme Court decision dealt with appeal procedural issues. And you're quite right, I think, to focus on mitigation, Callum, because that's really the nub of the case from a practitioner's perspective or, interested participants' perspective and the takeaways. But I think actually the procedural dimension to this is really fascinating, because such an experienced court, and I say this with the utmost respect, in the Court of Appeal, gone down a certain path in getting to a certain decision, I suppose, but in doing so has kind of, according to the Supreme Court, done it the wrong way, and has addressed matters that were not really determined by the tribunal. And I found that interplay between the courts and the way it's worked through the various levels fascinating. And I wondered if perhaps we kind of focus on that initially, and then we get into the mitigation and the actual underlying issue here that the arbitration panels and the courts ultimately had to rule on. And James, maybe I'll throw it to you. What did you make of the kind of procedural background to this? And perhaps if you could just recap as it kind of went through.
Just stepping back a second, it's I would say quite often said, I've certainly heard it said, that litigation at first instance is like trench warfare. And each side is trying to grind the other down, and then you move up to sort of some cavalry charges at the appellate level, and then the Supreme Court rides down from the hills and shoots the survivors. And there's a bit of a flavour of that to this case, isn't there? I mean, it's gone through two stages in arbitration, because commodity arbitration, like salvage and wreck removal arbitration, has an appellate level, and then it's found its way into the court. And what is interesting is that from the sort of personality point of view is that the instinct of Mr. Justice Jacobs, who gave permission to appeal, and I'll come on to the requirements around permission to appeal, but his instinct was this is just completely wrong, the decision the board had come to. And so it was a no-brainer for him to give permission, even though he thought it also raises a point of general public importance. It would have got through on the obviously wrong criterion. But when it came for Mrs. Justice Cockrell, she had a completely different view of the case and thought it couldn't be said that the appeal board had got it wrong at all. So dismissed the appeal, but did at least, and this is such a bottleneck in the appellate process, did at least grant permission for appeal to the Court of Appeal. Because one has seen over the years some cases which raised really interesting points be stopped by the first instance judge who has decided the appeal from the arbitration. And one always wonders why that was, and perhaps they didn't want to be found out by the Court of Appeal. And obviously if one's on the receiving end of that, you always feel hard done by. But the Supreme Court, it isn't quite rude enough to say this, but what they're saying between the lines is in the Court of Appeal, you can't just make stuff up.
They came pretty close. And that's what I felt. Like when I first read it, I'm like, oh, okay, yeah, and we all understand the deference to the courts and, the respect and all the rest of it. But yeah, I read it like that as well. It's like, okay, yeah.
Someone's being told to get back in their box here, which, given, as you say, that the stature of the judges in the Court of Appeal was quite almost fruity. So all of that was fascinating. I mean, in terms of the actual procedural background, the historical tradition was that it was always possible to take errors of law on the face of the award through the courts. But the trouble with that was that it undermined arbitration as a process, because arbitration was then just a sort of first shot, and if nobody liked it, then you had a second and third shot. And the law had evolved even by the time of the 96 Act to a point where, in order to appeal on a point of law, it had to be one that was raised with the tribunal below. It has to be one that matters. It has to be one which is either of general public importance or the arbitrators have got it obviously wrong. And then that was set in stone by the Section 69 of the 1996 Act. A lot of restrictions on what the court can do, even where it grants permission. It is stuck with the findings of fact made by the tribunal. I mean, if it feels that it, as in this case, actually, that having clarified the law, the arbitrators have to have another go at the facts, well, then that is what happens, and the award can be remitted to the tribunal in order for that to happen. So the court can't sort of colour in the blanks left by the findings of fact in the award.
James, I'm just pausing here for a minute, and I know this might be something we come on to down the track, but there is an interesting point in there, isn't there, around the inference of facts that the arbitrator's decision may have actually made. I thought that's quite an interesting discussion, and how they can be inferred as necessarily made, but you can't find facts that weren't actually found. They have to have been inferred in there.
Yeah, I mean, you can infer that the arbitrators have made a finding or drawn an inference. But you can't infer from the findings that they have made another finding.
Yeah.
So, I mean, how many angels you can get to dance on the head of your pin is another matter. But that is an important distinction, and one that the Court of Appeal, according to the Supreme Court at least, fell foul of in this case. To be fair, they went quite a long way beyond the facts, and I can understand it from an appellate court's perspective. It can be quite irksome not to be able to decide a case because the underlying facts don't quite go far enough, and you're very rarely constrained in that way where it's an appeal from a judgment. But when you're appealing for an arbitration award, that is a real constraint.
I've got to say, I and again, say this with the utmost respect, I've got a lot of sympathy for how the Court of Appeal dealt with the matter, in the sense that when I read through the background, and I hadn't followed this case previously. I'm reading this judgment fresh. for this pod. But as I read through it, and obviously it's in there for good reason, I'm like, well, what's the position on the actual contracts? Because the sellers did extend quite a bit of leniency to the buyers. They granted them more time. They discharged against an LOI. I probably did vary, although that wasn't argued, properly in the arbitration. But there was a whole lot there that when I first read it, I'm like, okay, so this is it's all going to be about this, and whether the contract had been varied and what the state was and when the date of default was, well after all of this had happened.
And the date of default that they picked wasn't even actually the date of default. It was just the date on which the Gujarat court stopped the buyers from interfering with the seller's right of resale.
Yeah, exactly, which is a curious date to pick, right?
They picked it because of everything that follows from picking the date of default, because the date of default then determines the date on which you have to go into the market and buy your replacement cargo. And if you can't, or in this case, go into the market and sell the cargo that has been refused, and if you can't actually sell the cargo because the buyer is sitting on it going, no, you can't have it, even though I haven't paid for it, then you wouldn't want that to be the consequence.
There was also an independent breach in there too, wasn't there? Because there was an obligation on the buyers to cooperate and to provide the documents. In the event that they don't pay, they're obliged to cooperate with the sellers to allow and facilitate a resale.
It may be worth at this point just talking through what happened, kind of play by play, so that our listeners can join us on the exploration of these issues around the default date and how did we get to this issue in the Gujarat courts. And maybe to start that off, just looking through in very brief, the fundamentals here is you have a sale contract, which is cost and free freight out Mundra. The goods are to be taken to Mundra. Effectively, on arrival of the goods, you have a payment default. And there are exchanges between the parties trying to remedy the payment default. They try and find a way through. They try some kind of payment plan, but it doesn't get them any further, and the payment default continues. And then during this period of payment default, the Indian government introduces this levy on the sort of goods that have been brought in. So effectively, the goods that are sat there suddenly become a lot more valuable than they would have otherwise been to that Indian market. And this then gives rise to a question about how you calculate damages, because obviously the party that's not paid are turning around and saying, no, even though we've not paid, even though we're in default, what you're left with is something very valuable. So we shouldn't be on the hook for big losses, because you should be going away to mitigate those losses, and you should be approaching this. You should be in the money right now, because what we've lost, you've gained, and therefore if you have a claim, it should be significantly reduced. But all of this played out over a reasonably long period of time, and as you say, there are orders of the local courts, and this all becomes relevant because the tribunal and later the court have to work out what the default date is. And you get into this, that kind of, to bring it back to what we're talking about here, you have the situation where I think, in a lot of the judgments that we've discussed on this podcast over the last few years, my impression of the Court of Appeal, perhaps in particular the Court of Appeal, again, I say this with respect, and it sounds like a silly thing to say, but it's quite sensible in its approach to commercial disputes. It tends to find when you read a Court of Appeal decision, they tend to take a sensible commercial view, and they tend to understand the commercial context. The judges that sit on the Court of Appeal bench are extremely well read in the kind of commercial disputes that we see a lot. They really understand the issues around international trade, and I can see why in that environment and in that court it would be almost unnatural to have your ability to make that sensible commercial decision fettered by what was argued years before in a GAFTA arbitration. Yeah. So you can almost see the frustration in the Court of Appeal saying, well, this is the thing we actually need to decide, and then the Supreme Court saying, well, yeah, but this is the thing you're allowed to decide. I think that's right. I think it would be rash to take away from this case any sense that a date of default under a contract of this sort is the date on which you get access to the goods.
But I'm not sure that that's right as a matter of law at all. Everyone's happy to proceed on that basis, and that's fine. And one can see why that is a good thing. But as I say, I'm not sure that that's actually right. And possibly, if the thing had been fought in the commercial court in the first place, the legal resolution would have been a different one. You'd have almost certainly ended up in the same place at the end, but the route by which you reached it would have been different. But it's left us with this fascinating procedural tussle, but then also the very good ruling on mitigation and markets.
Yeah, well, exactly. I completely agree. I think ultimately we end up at the same point, just through a different route. It is, though, for me, fascinating how even though an appellant court may want to, decide it in a certain way, as you say, Callum, for sound commercial legal reasons, that when you have a case that's come through from an appeal on a point of law from an arbitration award, there are safeguards and there are parameters on what the courts can and cannot do. And for me, that's one of the hallmarks. And I know we're going to get onto the mitigation discussion, but that for me is one of the real takeaways and hallmarks of this decision. Because how many times have we got an arbitration award where you might think, I didn't like that part of the decision, or it went against you entirely. Or the other side might be doing that on one that we've won, right? And you've got to look at it through a very is probably putting it too high, but you've got to look at it through a prism. If you're looking to appeal into the courts, you've got to look at it through a prism. And one of the practitioner points that I've got out of this decision is that this is a great case to go back and look at when you are assessing, well, is this an appeal point? Can we get this into the courts? What was the issue actually determined? Understanding that as an arbitration practitioner, you almost want to then go back a step as well and say, okay, well, if these are the potential issues that might end up in a court one day, these are the issues that we're going to end up fighting about, how am I going to run my arbitration that sets me up in a way that has certain issues actually determined, so that if they go against us on the point of law, maybe not on the facts, I can then take this into the courts. Like there's a lot to think of in there.
Yeah. There is. I mean, not least the challenge with experienced arbitrators is that they will, if they can avoid it, they will avoid deciding difficult points of law because they know they'll end up being appealed. And for some reason, arbitrators don't like that very much anymore, perhaps, than first instance judges. But I found the first ground of appeal, which was that the ground taken was that the Court of Appeal had itself restated the question of law, which you can't do. You can only have the question of law for which permission has been given. And this is a perennial issue when you're appealing from or seeking permission to appeal from an arbitration award, because you obviously try and get it in through the general public importance gateway, because that makes life much easier in terms of arguing just how wrong the tribunal has got it. And it's very common to see questions framed in a very broad way. And I've had quite a lot of success in knocking them out and saying, well, you've asked too broad a question, because the answer to this question in truth is, it depends. If you can get past that, then it's okay to sort of fine tune the question, so long as it's fundamentally the same question in the dispute as a whole, then that's okay. And one sees the Supreme Court here, Lord Hamlin, saying, yeah, fine tuning is okay. And what was happening here was fine tuning. So, so far so good, and then rather lays into them on the other 2 points. But that articulation at the permission stage of challenging an arbitration award of the question of law is absolutely critical. Neither being so narrow that it really is just a one-off point that where you've got to show then that the tribunal's got it hopelessly wrong, or so broad that some smart aleck on the other side can't come along and go, no, this is too broad. It's not really the question that the tribunal is having to decide.
I was going to say this is all a creature of legislation, right? This all flows through Section 69 Arbitration Act 1996, which, as we all know, is in the process of being the Arbitration Act. I think the bill is ready to go through it, and potentially would have gone through by now were it not for the fact that we're about to have a general election. I can't recall off the top of my head the extent to which this would be changed. I don't think that Section 69 is significantly changed at all by the revised bill. So this will survive Arbitration Act 24 or 25 whenever it ultimately passes Commons.
As Luke rightly said, I mean, almost no other jurisdictions have permission to appeal at all. I think in Hong Kong you can opt into it, but I don't get the impression that option is taken very often. Maybe that is unfair, but most places around the world look at Section 69 and go, what on earth are you doing? Because this is really, really unusual. I think it's right that if we're going to have any sort of appeal mechanism from arbitration awards, that it be kept very narrow. And of course, people can opt out of it. I mean, with the obverse of Hong Kong, you can opt out of the appellate process, either by selecting institutional rules which oust the right to appeal, or by just ruling it out in your arbitration clause.
We've seen arguments before that the wording in arbitration clauses is sufficient to exclude an appeal. There's some interesting discussion to be had on that as well, where the arbitration agreement says that the arbitrators will come up with a final binding award or something, and then people say, well, that's an exclusion of the Section 69 right. We've had those fun arguments in the past, but as you say, this is something that the parties can agree doesn't apply. But it's one of the strengths, in my view, of the maritime arbitration that you see in London, one of the, or at least the development of maritime law in London. One of the strengths of it is the Section 69 appeal right, because you have a lot of disputes that go through the LMAA where there is no exclusion of Section 69, which does give us interesting cases to discuss. And it does mean that the body of law grows and grows and grows, and that would be stymied if all of the arbitrations were to never go beyond the confidentiality of the arbitrations themselves.
But it's an interesting case to explore that, isn't it? Because I can see arguments for and against the 69 with this type of case, because it's taken a while. I think the contracts were 2017. We're in 2024. We've gone through 6 layers if you got the permission judge in there as well. Ultimately, get to the right decision, I think. So we got the right outcome, but we went through quite a few levels to get there, right?
It took a while, but I mean, 3 years from granting permission to Supreme Court judgment. True. That's not bad. There aren't many jurisdictions which would do significantly faster, I think. Yeah. But then I have several cases running which haven't reached first instance yet, that come from a pre-pandemic time. Yeah. So
moving on to the second ground of appeal, and this is the one where did the Court of Appeal err in deciding a question of law which the appeal board were not asked to determine, and on which it did not make a decision? So this is the first ground of appeal that was successful. And I think perhaps we might want to just go back to looking at what's the issue we're looking at here.
How this arose is that in the Court of Appeal, they found that there had been, as a fact, that there had been a variation of the contracts and that the goods had been discharged against the bills of lading. And in order to make that finding a fact, they interpolated the word discharge into the letter of indemnity, which had been given for the discharge. I mean, just pausing there, that's a slightly odd inference to draw, it seems to me, because normally you present a letter of indemnity precisely because you're not discharging against the original bills of lading. So what the function of an LOI would be where you are discharging against the original bills of lading is not immediately obvious. Anyway.
Yeah, I think it was argued that whether discharge should be inferred into that sentence or not was a question of construction. Right? And I go back to the cases like the Zenovia where you had an arbitration panel and then the subsequent debate about whether WP means whether permitting or without prejudice. Like, there are, just to read in a word like that may or may not have been omitted. I don't know. It didn't jump out at me as a construction issue.
Exactly, but it was in the light of that holding that there had been a variation, that the Court of Appeal said, the appeal board went wrong in treating the appeal board went wrong in treating the notional substitute contract as it had done as one that was itself on the same term, C&FFO, Mundra, and said no, it should go back and reconsider based on the variation that the Court of Appeal had found. Just for our listeners, C&FFO means cost is an abbreviation meaning cost and freight. So you pay for the cost of the goods, the freight, which is the carriage charge, and free out means that the discharge costs are borne by the buyer rather than the seller, as distinct from liner out, where the ship and therefore the seller will bear that cost. And that had a role in this case because the buyer itself did in fact pay for the discharge, and the costs of the discharge were then a further deduction from the damages that were awarded. That part of it wasn't challenged. So that was the point, I think. And so the second ground was this question of variation one which the appeal board was ever asked to decide? Because if it wasn't, then under Section 69, the court can't be deciding it, because you can only decide a question of law which was fairly and squarely before the tribunal for its determination. Leading counsel, my fellow Quadrant Chambers colleague, Chirag Karia QC, was compelled to accept that there had never been argument before the Board of Appeal that there had been a variation in the contract, or that any variation was relevant to the issue of damages. And so given that concession rightly made, the answer on this point was always on the wall, I think.
Yeah, and I think the one kind of emphasis that Lord Hamblin put on this was building on the Safeway Stores authority, that all that is needed in my judgment is that the point was fairly and squarely before the arbitrator, whether or not it was actually articulate as a question of law. That's the Safeway Stores point. But Lord Hamlin's emphasised that it's got to be before the arbitration tribunal for determination. And this issue just wasn't before the tribunal for determination, let alone fairly and squarely. So moving on, that brings us on to the third ground of appeal, and that is whether the Court of Appeal erred in making findings of fact on matters which the appeal board had made no finding. And this one also went the way of the appellant.
And this brought up the famous dictum of Lord Justice Steyn in Geogas and Tramogas, where he said the only inferences which a court might arguably be able to draw from arbitrators' findings of fact are those which are truly beyond rational argument. And I don't know which members of the bar he had in mind when he was thinking of what might be truly beyond rational argument, but there are some people at the commercial bar who are quite capable of putting up arguments which sound wonderful, and then you sit and think about it and go, yeah, that's not even rational. It's,
and that may be a test too high, according to the Supreme Court.
Lord Hamlin said, well, that might just put it a smidgen too high.
Yeah.
But it has to follow inevitably from the findings that have been made, which means that the findings themselves are resting on the inference that you're looking for, not that you can leap from those findings to something going the other way, going beyond. And this, in a sense, was the flip side of the discussion we've just been having about, was there a variation of the contract which was premised on inference drawn by the court that the cargo had been discharged against the bills of lading. And they thought that was an obvious inference. but it wasn't that obvious at all. And I've already given one reason why not, and junior counsel for the sellers. And I'm just parenthetically, I mean, I really like the way that the courts are encouraging juniors to speak in at first instance in the Court of Appeal, in the Supreme Court. I mean, I've sat as a silk, one of three for my party in the Supreme Court, and never got to say more than "No, my lord" when asked if I had anything to add. And so this whole encouragement of a significant speaking part for juniors, I think, is a really good thing.
There's recognition in the judgment as well, as to who made the argument. I completely agree with you.
And we've seen this in other cases, not at Supreme Court level, but I do remember there was a case that we covered on this podcast in the High Court between two juniors, both of whom we know quite well as a firm, and the judge made a particular point at the end of the judgment to say this was, that there were no silks involved. The sums perhaps didn't justify silks being involved, but it was very well argued. It was, it was kind of refreshing to see two juniors arguing this in front without silk, and that it was very much encouraged that more do the same.
Anyway, returning to the case at hand, this was effectively the assault on the Court of Appeal's finding that there had been discharge against the bills of lading. And there were 4 good reasons why that finding was probably wrong anyway. But it was just not one that was open to the Court of Appeal. It was not something that the Board of Appeal had found, and it was not something which leapt off the page of their findings.
So ultimately, from on the appeal, the appeal was dismissed on ground 1, but was allowed on grounds 2 and 3. And so the appeal succeeded, but we then have a cross appeal to deal with.
But before we go to the cross appeal, I mean, one of the things that troubles me about this is that this may not be the first or the last time that a court goes slightly adrift within the parameters set by Section 69. And ordinarily, you only get permission to appeal to the Supreme Court if the Supreme Court thinks there's something novel here or some point that it needs to nail down. The point has now been nailed down. So the next time this happens, should ever happen again, or perhaps on one of the other parameters in Section 69, such as it's got to actually have made a difference to the decision. If this happens again, then it may not get back to the Supreme Court, and the door will be shut. So it will be interesting over time just to keep an eye on whether things are as they should be in Section 69 country. There are jurisdictions, Germany, for instance, where if the appellate court has made an obvious error of law, you can still appeal to the Supreme Court, even though it's not a new point, because it's an obvious error of law. I mean, where's the new point in that? But that's just not the case in England and Wales or the United Kingdom. I think it's a very salutary experience and feature to see cases like this where the Court of Appeal has said, no, you're running off the rails here, and put you back on the rails. But having put you back on the rails, what oversight can remain to do that?
If this were to happen again and the Court of Appeal were to go off the rails, then the Supreme Court would say, well, actually, we've already dealt with this, so we can't correct the Court of Appeal in this second case because the principle of law is already settled. So yes, they might be wrong, but the principle of law is settled, so we can't tell them they're wrong a second time.
That would be the risk. That would be the risk. I mean, things are never that clear cut. So the argument would be there would no doubt be another substantive point, as there was in this case on the cross appeal. But the argument would be we think they've gone off the rails here. The Court of Appeal would dress it up in a way that showed that they haven't, and the Supreme Court would say, well, we're not interested because we've already dealt with this.
Yeah, there's some really interesting points in here on mitigation. I think it's a helpful primer in a way. Whether, coming back to your original question, Callum, does it actually change things? I'm not so sure it does, unless I'm missing something. But yeah, let's get into it. Well, what did you make of this section, James?
Well, I think I'm with Callum on this. I mean, the truth of the matter is that particularly in the paradigm case of sale of goods where either the seller fails to deliver or the buyer refuses to accept, there's statute law, which is now 130 years old, which itself is built on the bedrock of some pretty consistent common law. And mitigation is absolutely woven into the remedy that is given by statute. So in this particular area, yes, it's obvious that the compensatory principle, which is the principle that the innocent party be put back in the position they would have been in if the contract had been performed, is intertwined with the mitigation principle, which is that if you've made your own loss worse by your independent action, then you don't get to claim that worsening. And in the context of sale of goods, the expectation is that if, say, you are the buyer that hasn't had his goods delivered, the expectation is you go out into the market on the day of default and buy a replacement. That's the expectation of the statute, and the two are just they're not even two sides of the same coin. They're two threads in the same weave of rope. It seems to me they're absolutely cheek by jowl, and there's lots of case law on it, and it's very nicely set out in this section of judgment. I think you're absolutely right, Luke, that it's a very good primer on the approach of the law, particularly in the context of sale of goods. Well, certainly the Board of Trade really went wrong, is getting tangled up in identifying the correct market. It's all very well saying go out into the market, but what's your market? And what your market is change? Does it change? And if so, how does it change during the evolution of a sale of goods a transaction, where the goods start in one place and they end in another, and they do or should end in another, but they maybe stop halfway. What at any point along this chain is the market that you're expected to go into? That's the real interest here, I think. I mean, I don't think the articulation that mitigation is, just as important as the compensatory principle. In this particular setting, yeah, of course it is, because that's what the statutes have said for a very long time.
When you're looking at something like the compensatory principle, you really have to dig into the facts of what actually was the loss. And I think that perhaps one of the issues here was that what the sellers were trying to argue was kind of a bit of a gloss on the actual facts, and they were saying, well, we just take the contract, go back to what the contract says, and then the contract will tell you that the comparator will be with this other contract. But as you say, the nature of the loss changes and shifts as you go on this very real journey, which the cargo has been on. And then shifts again when you have this imposition of tariffs that increase the value of the goods in the place of discharge. So when you dig into the facts, you can actually see quite clearly that the loss is different on day X to what it is on day X plus 30.
We've got in the kind of two competing positions here. We've got the sellers who are arguing that the market value of these goods that had actually already been delivered was the price of the goods back in Vancouver. We've got these goods coming from Canada plus the freight on top of that. The buyers, on the other hand, were saying, no, these goods are already in India, and and they've been custom cleared. There's the import tariff issue has meant that those goods are now more valuable, landed, ready to sell into the Indian market. And the buyers are saying, look, the sellers have the benefit of these more valuable goods sitting there in India, which they're going to sell into the Indian market, which they did. The buyers should get the benefit of that increase in the value, or indeed the sellers shouldn't have some windfall on this. And so those are the two positions here. And I think the seller's argument is kind of facially attractive, because that's kind of how it's typically measured, right? You look at, what's the international market for the goods, and you go with that. Whereas, and I think this is to kind of put an exclamation mark on what you're saying, Callum, you need to look at the actual facts in play here. And here you've got goods that were landed, that were warehoused, that were custom cleared, that were then ultimately sold into the local market. And, I think that's what we've seen. We've seen the Court of Appeal kind of contort its way around to find a reason to say, well, actually, it should be the value of the goods as they were after all the contract variations and all the rest of it. And as I say, I can see why they went down that route, albeit they might not have been allowed to. But it was all about, well, look, the seller's got the benefit of these goods that were increased value in India.
I think there's often a sense by arbitrators or by, well, I think there are two things at play. One is that there's always a sense by arbitrators and judges that somehow someone is getting away from it, getting away with it, if because of developments for which they're not responsible, they've had no hand in, and so why should they get the benefit of? Suddenly the damages which they should be paying are greatly reduced. And it seems just unfair somehow, and they should be held to account or held to their bargain, and whatever grandiose term you want to come up with, which says that no, we're gonna find a way to make you pay more money. So I think there's a sort of human aspect of it. I think the other thing, and this is only a suspicion on my part because it's not my case, I didn't live it. Lord Hobhouse, when sitting as a first instance judge, I think, and in a completely different context, said something which I think resonates throughout the common law system. He said, this case, to my mind, exemplifies the excessive intrusion of authority into questions of fact. It is very tempting, particularly as a young advocate, but I've seen, Michael Collett is same vintage as me, so I've seen very sophisticated advocates do the same thing, is just encourage factual findings by reference to what has been said and done in other cases. And if you don't analyze those other cases properly, in terms of what is actually being decided and the factual setting in which that decision is being made, in order to make sure that when you're looking at your own facts, you're comparing apples and apples and not apples and lentils, or, as in this case, I would say you can go off beam. You can persuade a tribunal to go off beam, unless you've got someone pretty firm on the other side going, no. What you're doing is a sort of the legal equivalent of an illusionist. You're making something appear as though it's disappearing, where in fact it's not doing that at all. And I think it's a hunch on my part that those two elements have a role to play in this case. And the difficulty with that sort of approach is that eventually you meet Lord Hamblin and the whole thing crumbles to dust.
Yeah, it's a really interesting point. We've had this, as I mentioned, we've argued a few cases ourselves, not to the level of yourself, of course, James, but one of the first things we do when there's an argument being put on the basis of some authority is to look back at that authority and say, what was it actually based on? What was that legal decision based on factually? And often, we do this when we're wanting to rely on a case that may be a bit of a stretch, right? It's part of the advocacy process or the adversarial process. But if you go back and look, often there's some distinguishing feature, or the authority that's relied on doesn't really sit on the point that they needed to sit on. It also brings me on to another point which Cal and I have discussed a number of times, and that's the pros and cons of having arbitration on the papers versus oral advocacy. Because we've seen a number of decisions where decisions have been made by experienced arbitrators, LMA arbitrators, or what have you, where the decision's been made on the papers alone, and there hasn't been that interrogation of the authorities. And it can lead to, I'm not saying in every case, and of course there are cases where it's appropriate for paper-based decisions, but that ability to really interrogate the authority and get into it and tease it out, which it can be done in an oral setting much better, I think. Yeah, it's one of the reasons we tend to prefer oral hearings if we can get them.
Just having the opportunity to say to counsel that I just want you to help me with this point, which is code for one of two things. Either I think you're right, but I don't think you're quite putting it in the right way, or more often, I just don't think you are right on this. So just try and persuade me, because my mind is as open as the next person's, but you're going to have to persuade me on this point. And you've already had one or two or three, sometimes more rounds of paper at that point. Yeah. And so that interchange, that dialectic, if you like, is absolutely critical.
And just going back to a point that you made earlier, James, on mitigation and the fact that you sometimes get these unfair results, if you like, where the breaching party gets away with it, or I suppose it's just a feature of the way that English law operates, is that you all you get is what you lost. The only slight spin on that, I would say, is that there is this body of law around measuring loss as at a certain date, even if you then commercially go and decide to do something different. And I'm thinking of the new flamenco in particular, where you had, I can't remember exactly how the timing all worked, but effectively I think it was a ship owner who repudiated the charter party. Maybe it's the other way around. Maybe there's a repudiation against them. But either way, I think it was the charter who repudiated the charter party. The ship owner then had a vessel available, put it into a put it up for sale, and made a massive windfall compared to what the price of the vessel would have been if the charter had been concluded. And the court said, no, you don't have to take into account the windfall, because what you lost was the charter, and what you get back is the value of another charter, even though you've also made a windfall. And so there's this tension, I guess, between true compensatory principle for what actually in fact happens, and what the compensatory principle really is, which is on the basis of a detailed factual inquiry at the point of this default, what was the actual loss to you versus contractual performance?
There, of course, are two bases upon which quantum could have been claimed, right? Yeah. What actually happened here was that Glencore went on to sell the cargo to associated companies, not at arm's length companies. But had they not done that, had they sold into a market and had they mitigated by selling the cargo reasonably and acted, they could have framed their claim on the basis of actual losses. There's the alternative way of framing this. Presumably they didn't. They couldn't, one, because it wasn't at arm's length, but two, they probably did pretty well out of the Indian market selling that cargo given the market conditions. And I think the legal principles here, work well. It's kind of tried to say that, but they work well in a very volatile market where you have situations that go one way or the other way. And how many cases, if not most of the cases, are dependent on what markets are moving and markets are doing. If that hadn't happened here, we probably wouldn't have this case. It's because of that import change that we've got a bit of a debate here.
Absolutely. I mean, I would say a very large percentage of my work is market driven. And without them move in the market at some point, they wouldn't have happened. I mean, that was spectacularly so in the aftermath of the financial crisis. Yeah. One of my particular fields is shipbuilding, and we were just deluged with cases which would not have happened if the market hadn't changed as suddenly and violently as it did.
We've seen it again, maybe not with quite the violence of 2008, but coming out of COVID, particularly in the in some fields of shipping, the market had an extremely volatile period, and again with the Red Sea, the markets have been volatile in certain areas.
Well, look, I think we've really gotten into this. I've got to say I've thoroughly enjoyed it. Time has just flown for me. Any final comments on the case or otherwise?
I think I just want to end by paying tribute to, I think it was Herbert Smith who published an article on it saying, Supreme Court keeps its finger on the pulse.
Very good.
Yeah, that's good. That's good. Yeah, we'll give them that one.
I would just like to thank James again for joining us. I really enjoyed it. It was fun to talk with you through a case like this. And really do appreciate the time. It's very generous of you.
Well, not at all. Thank you both very much for having me. It's been great fun.
Thank you very much, James. And thank you, everyone, for listening in. If you've gotten this far, we hope you've enjoyed the discussion. And in the usual way, you can subscribe on the channels. And James is, as we heard earlier, active on LinkedIn. So if you want to follow him and what he's got to say, that's the place to do it. And of course, I'm sure many of our listeners will be working with James in some capacity. So thanks for listening in, and until next time, take care, everyone.